Welcome. I see the attendees are coming in. Please do share the link. We are on Facebook live stream. So do share our link on it's available at our Facebook at Women's Tribunal Malaysia. We will start shortly at 9:30 a.m. So we still have time. Do share the link to your family and friends. welcome. Hello, everybody. I hope everyone has had time to have breakfast. Here is just a bit of an information. We do provide Bahasa Malaysia interpretation. Just head to your Zoom function bar. There is a function for interpretation and you can select Bahasa. Please also select mute original audio. Thank you. We will start shortly at 9:30 a.m. Thank you. Good morning and welcome to day 4 of the Women's Tribunal Malaysia. I'd just like to remind everyone again that we do have the interpreters function. So if you'd like to listen in Bahasa, you can select the interpretation function. It's at your Zoom function bar on the lower right. Don't forget to mute original audio. We will now start. Good morning, selamat pagi, and welcome back to the Women's Tribunal Malaysia. It's me again. My name is Grazele Jenarun, and I'm your Presiding Officer for the Tribunal. Thank you everyone for joining us and staying with us. Last weekend, we have heard the 26 testimonies and 9 advocate statements. And today, we will listen to the findings and recommendations from our judges. Before we start, audiences were captivated by Ren Xin's performance during the Kebahagiaan Dirimu Arts Festival last Monday on 30th November. Ren Xin is a dance artist interested in how the body carries, reflects, embodies, and co-creates with place and time. We now showcase her performance once again. Please watch the video.
One touch, it could have been a fluke. Twice now, he was up to no good. Sat down, couldn't say a word. Limbs weak like a broken little bird. trust and goodness, things that he did not know, leaving spirits broken and unwhole. Build your temple brick by brick, keep it under lock and key, and welcome feet, make it unclean, can wash away what you can't see. Build your temple brick by brick, keep it under lock and key, and welcome feet, make it unclean, can wash away what you can't see. Bloodless wounds need time to heal. Tainted temples need time to rebuild. Smiling, his voice held no trace, hiding intention to betray. Anger came a little too late, courage was to be delayed. Now his hands smile, they make no sound. Buried deep, deep underground. Build your temple brick by brick, keep it under lock and key, and welcome feet, make it unclean, can wash away what you can't see. Build your temple brick by brick, keep it under lock and key, and welcome feet, make it unclean, can wash away what you can't see. Bloodless wounds need time to heal. Tainted temples need time to rebuild. Bloodless wounds need time to heal. Tainted temples need time to rebuild.
Thank you, Ren Xin. We now bring you some of the highlights from the tribunal last weekend. Please watch this video prepared by Praveen Premnath, our communications officer for the Women's Tribunal.
Discriminations against women still exist in laws. For example, in areas such as marital rape, the right to confer citizenship to their children in certain circumstances, and laws pertaining to permanent residence for a foreign wife. This indicates that there is still a lot that remains to be done. The linkages between human rights and women-related issues have become topical subjects of conversations, not only in Malaysia, but also globally. It is timely that the government adopt a right-based approach to deal with existing discriminatory laws and policies.
And all of the CEDAW state party should take into account the General Recommendation 33 on access to justice under Article 1 and 2 of the Convention. And as UN Women said, unhindered access to justice for women is a critical pathway for the achievement of gender equality. Justice ensures the protection of economic assets, bodily integrity, and political voice, and provide redress when such protections are violated or compromised. Respect and protection of human rights can only be guaranteed only if effective domestic remedies are available. Legal rights are meaningful only if they are asserted. Access to justice is therefore an essential component of rule of law and means for women to actively claim the entire range of human rights, including those articulated in the CEDAW Convention.
Unfortunately, as an expert of the UN Committee on Economic, Social, and Cultural Rights, I cannot use these testimonies in the examination of Malaysia in my committee, because Malaysia, unfortunately, still did not ratify this important treaty monitored by my committee, which is the International Covenant on Economic, Social, and Cultural Rights. Article 3 of this covenant guarantees that the state parties should do their obligation so that women can enjoy economic, social, and cultural rights as equally as men in all areas. Malaysia did not ratify the other covenant on civil and political rights either. So please work towards ratification of these two core international human rights treaties.
I hope this tribunal is able to bring to light and to share to everyone in Malaysia the life that survivors of stalking face. There must be so many more who go through this on a daily basis, but they have no way to speak up. It is high time we make stalking and harassment, offline and online, a crime. What if some victims don't have the support that I do? Would it drive them to further mental and emotional distress, even self-harm? We must not take this chance.
The country that is supposed to be protecting me, yet as a single mother, I'm put into extreme vulnerability and insecurity, and in constant fear of losing my children. My eldest daughter have exactly 5 years left in Malaysia. If I do not get citizenship for her, I might lose her.
Dan saya berharaplah dibagi hak yang sama ada dari segi pendidikan, pekerjaan dan juga hak mutlak sebagai rakyat Malaysia. Terima kasih.
Elements of indigenous curriculum and indigenous pedagogy should be strategically integrated into the existing system used in orang asli classrooms. Apart from that, we should also establish more community schools or community learning centers where government and non-government agencies alike can partner with local communities by providing training to the community, particularly the mothers.
Focus on the government. And the reason is that only government has the resources needed to effectively address violence against women, but also only government has the legitimacy to enforce laws that sometimes needed to stop violence. So I suggest here 3 overarching recommendations to the government. First, the government must adequately fund services to respond to violence against women. The government budget generally has not prioritized violence against women response.
Thank you, Pravin, for that video. Before I invite the judges for their findings, let me remind everyone who the judges are. We have with us today Shanthi Dairiam, who founded the International Women's Rights Action Watch Asia Pacific in 1993, of which she is now the founding director. She was also a UN committee member on the elimination of all forms of discrimination against women from 2005 to 2008. Zainah Anwar, our next judge, is the co-founder of Sisters in Islam in Malaysia and Musawa, the global movement for equality and justice in the Muslim family. And Nadia Malayanah, who is UNDI 18's program associate, and she advocates for higher political participation and representation of Malaysian women at 111 Initiative. To start off, we now invite Shanthi Dairiam to give us the preamble. Please go ahead, Shanthi. Sorry, I think there is. Can you start again, Shanthi? We didn't hear the first part.
Okay. The judges have completed their deliberations and are here to present our findings and recommendations. But first, the preamble. On the 27th and 28th of November, 26 women, cis and trans, gave their testimonies of human rights infringements and violations they had experienced in several contexts at the Women's Tribunal Malaysia, initiated and organized by the Joint Action Group for Gender Equality, together with Gender Consultancy. While the violations were contextual, according to the situations of the women, what was common to all of them, however, was a lack of adherence to the overarching constitutional guarantees of equality and non-discrimination, Article 8.1 and 2 of the Malaysian Federal Constitution, and the non-recognition of the very foundation of the Federal Constitution, which is the basic structure doctrine. The problems originate from prevailing political culture and socio-cultural norms that ignore these fundamental values and principles. For the women who gave their testimonies, equality and non-discrimination, though entrenched in the Constitution, is not a value or a principle that has protected them or upheld their rights. These principles are not understood or applied for the protection of the most vulnerable women, leading to violations of their rights. This is regrettable, as Malaysia is a party to the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and has undertaken legally binding obligations to progressively eliminate all discrimination against women and enable the achievement of their right to equality. The commitment to this obligation was undertaken by Malaysia 26 years ago. The achievement of equality for women must be substantive. It requires not only formal legal equality as provided for in Article 8.1 of the Constitution, but also it demands equality of results in real terms. In other words, the practical realization of equal rights as provided for or demanded by CEDAW Article 2.8. CEDAW provides a very enlightened definition of discrimination by identifying that discrimination is socially constructed and that neutral laws, policies, and practices can unintentionally have the effect of discriminating against women. This is referred to as indirect discrimination in Article 1 of CEDAW. The concept of neutrality as discrimination requires that consideration be given to pre-existing inequality and disadvantage that women may bear due to historical and existing socially constructed discriminations they face. Further, different groups of women face different and multiple forms of discrimination. Hence, a contextual, intersectional, and diversified approach to the elimination of discrimination is essential. CEDAW's requirement of substantive equality and freedom from discrimination, which may occur in the private and public sphere, provides a theoretical framework by which the state is obligated to identify all barriers to women's advancement, assess needs, set goals, identify measures for action, and assess accomplishments. Only prohibiting discrimination as provided for in Article 8.2 of the Constitution is inadequate. The model of substantive equality or the practical realization of the right to equality requires an understanding also of the multidimensional nature of equality. This concept of equality is applicable to all development issues, initiatives, be it poverty eradication, employment, betterment of health, etc., and in varying contexts, whether rural or urban. It is imperative that the multidimensional needs of the most vulnerable, in particular, are addressed through development practice as manifested in Malaysia's 5-year plans and in the SDG goals implementation. Only then will the SDG goals intention of leave no one behind becomes a reality. The multidimensional model of equality that has to be adopted, therefore, is about equality of opportunity, equality of access to the opportunity, and equality of results. Understanding this concept of equality of access in particular is very critical. It requires that people are treated differently so that this results in similar opportunities and choices being guaranteed to women and other vulnerable groups according to their differing situations. Amartya Sen says, equal consideration for all may demand very unequal treatment in favor of the disadvantaged. Malaysia's development strategies have to be assessed for their effectiveness in uplifting the most vulnerable from the cycle of intergenerational poverty they are trapped in. Fundamental liberties are independent, interdependent, and part of our basic constitutional structure. As the federal constitution is the supreme law of Malaysia, any laws or actions that contravene or are inconsistent with it shall be void, Article 4.1 of the federal constitution. However, the Federal Court of Malaysia has additionally recognized the preeminence of fundamental rights under the federal constitution as part of the basic structure and identity of our constitution. As such, when it comes to human rights, the courts in Malaysia are empowered to scrutinize the constitutionality of any law or government policy or action from two perspectives. The courts will consider whether the law, policy, or action contravenes the express words of the Constitution, and the courts will examine whether the law, policy, or action undermines or is an attempt to undermine the special status accorded to fundamental rights as a fundamental component of the basic structure of the federal constitution. The courts in Malaysia have also recognized two further core principles of the international human rights law. Fundamental rights and provisions must be construed as broadly as possible, while provisions which limit those rights must be constituted as narrowly as possible. When construing interrelated provisions, the courts will read them as a whole, having regard to the purpose and intent of those provisions and harmonize their collective meaning. Fundamental rights are interconnected, and certain fundamental rights, such as the right to life and liberty, are foundational rights in that the deprivation of a foundational right may affect other aspects of human freedom and dignity. Therefore, the violation of any one human right cannot be considered in isolation, but must be scrutinized for the impact it may have on the ability of a person to exercise and enjoy other fundamental rights. Applying these legal principles to some of the cases we heard at the Women's Tribunal, enjoying the right to education will go a long way to enabling a person to find work with decent living wages. That in turn will provide them with shelter and food. Even more significant is the compulsion to consider how human rights and fundamental freedoms can be read as linked to other rights such as citizenship, which is in fact governed by Part 3 of the Federal Constitution, a concept so inextricably linked to the right to life and personal liberty contained in Article 5.1. Any restriction should be read harmoniously with the more positive elements of fundamental liberties guaranteed in the Federal Constitution. Having heard the 26 testimonies, the judges have come to a collective view that all these women have endured serious violations of their rights. For them, justice has not been served. And you will hear details from all of us as judges. Using the basic structure doctrine coupled with the interrelated nature of human rights forms a powerful frame on which to claim rights for women. Thank you.
Thank you, Shanthi. Please remain for your presentation. We will now move into the judges' presentation and on findings and recommendations. Before that, I'd like to remind Shanthi, please speak slowly to allow the interpreters to translate. I now invite Shanthi to present her findings on inequality and violations at work. Over to you, Shanthi.
Yeah, thank you, Grazele. I will now speak to the topic inequality and violations at work, where we have put together a few testimonies that have some commonality in relation to work and violations at work. The experiences of women at work requires serious consideration. The testimonies shared by 8 women at this tribunal illustrate a range of circumstances where women workers experience varying types of harassment and intimidation and find themselves in positions that affect their livelihoods, health, and general well-being. Underpinning this reality is misogyny and, in my view, the hostility of many men to sharing public space with women on an equal basis. While 8 women gave accounts of the human rights violations they have experienced at work, the findings and recommendations here focus on the testimonies of 3 witnesses, Leslie, Siti Noor, and Lata. Some of these are pseudonyms. The rest are addressed under the contract workers and domestic worker findings and recommendations presented after this. The differing context of the 3 women involve a range and diversity of cruel and degrading treatment, harassment, and intimidation. Their ill treatment and discrimination on the basis of sex constitute a violation of their fundamental rights under the Federal Constitution, other laws, and international obligations of the state. The specific issues of concern are as follows. Number 1, there's a toxic sexist work environment and prevalence of harassment in the workplace. Male colleagues make offensive and sexist remarks or jokes in the workplace, and it happens especially if men outnumber women in senior positions. There's an interrelationship there. This is a situation of a work environment that does not consciously bring women into decision-making processes and posts. In the case of Leslie, a sports coach, meetings are always held in the boss's house, and an uneasy environment is created because of rape jokes he makes during the meeting. He further invites her to socialize, eat, and drink at his house, and even sleep over, and goes into a rage if she refuses. Next, there is a non-recognition or lack of acceptance of women who excel in a male-dominated sphere. As a sports coach, Leslie was constantly verbally harassed, bullied, and belittled by her boss, and subjected to degrading treatment. The harassment even extended to her parents. She was only given minor assignments or the coaching of female players or young people, or youth, and was eventually withdrawn from coaching and assigned irrelevant work. Her confidence was undermined. The attempt here is to put women in their place so they don't venture into male-dominated areas and they don't aspire. It is also the consequence of Leslie not responding to the unwanted advances of her boss. Next, there is a disparity or a gap which has led to a lack of diversity in senior management positions on the basis of sex. Siti Noor, the next witness, is a professional employed in a team comprising mainly of women, but led by a team of men. Her experience is that office practices were not conducive for upward mobility of the female staff internally, as such opportunities are not transparent. They are discussed when male colleagues socialize among themselves, thus excluding women workers. These are discriminatory office practices. This happens despite the fact that the women were capable or even more capable at times than men. The lesson learned here is that discrimination can occur because of institutional practices. It is not always that there will be an individual victim and an individual perpetrator. Relating to City Nor again, the next point is that there was a lack of reasonable accommodation of the special needs, example, of disabilities of individual workers. City Nor has health issues, which constitutes a form of disability requiring reasonable accommodation in terms of time for health care. But this is used against her, and she's denied positions or opportunities that she has applied for, though she fulfills all her KPIs. Nevertheless, the time that she requires for her health appointments is used against her, and this is direct discrimination that has no basis. The next point is precarious conditions of work. Lata's testimony clearly outlines the discrimination, stigma, dehumanization, and injustices that sex workers experience on the basis of their work. Married at the age of 15 to an abusive husband and desperate to feed 5 children, Lata is coerced and deceived into sex work by her brother-in-law. She faces violence from clients, is exploited by brothel owners, made to work unreasonably long hours even when she's menstruating, had her wages withheld, and had no access to health services because of the stigma attached to sex work and the prejudice of service providers. She has also faced police abuse and been subjected to degrading treatment, example, made to strip naked by the police. The lack of recognition of sex work as work exacerbates the precariousness of the experiences of sex workers as they're unable to access social, economic, and legal protection, including health, housing, employment, and social benefits, and access to other services. Worse, the laws in Malaysia are used to penalize the work that they do. Criminalization of various aspects of sex work render these workers vulnerable to further exploitation and violations by police, clients, the family, and by other actors. The next point goes to rights denied, standards not met, and failure of the state. Leslie, City Nor, and Lata have been denied a number of rights under both national and international laws. For example, the right to decent work and livelihood guaranteed under Article 5.1 of the Federal Constitution, which speaks of the right to life and liberty, and the right to equality and non-discrimination, Article 8.1 and 8.2 of the Federal Constitution. Other rights include the right to be treated with dignity, the right to be free of cruel, inhuman, and degrading treatment, the right to mental and emotional well-being, the right to reasonable accommodation of special needs, the right to a safe workplace, adequate health care, housing, social protection, and services. Access to justice, including legal protection, the right to remedy, and the right to protection from sexual harassment. A whole slew of rights have been denied to them. Besides the Federal Constitution, these rights are provided for under the Employment Act, the Industrial Relations Act 1967, and the Persons with Disability Act, as well as the Universal Declaration of Human Rights, CEDAW, Articles 2, 4, and 11, and General Recommendations of CEDAW 19, 28, and 35, and the UN Convention on the Rights of Persons with Disability. The following are some of the state failure that can be identified. The lack of government regulations to enforce positive duties on all employers to put in place a policy and definition of appropriate workplace behavior and prohibition of inappropriate behavior or procedures for addressing inappropriate behavior when it occurs in the workplace. B, the lack of government regulations to compel a policy and plan on equality of opportunity and results, which will include targets for increasing women in management and senior positions, closing sex-based gaps in wages and positions. And therefore, there is no compliance with Article 8 of the Constitution and inadequate compliance with international equality obligation under CEDAW for the practical realization of the principle of equality. Disability is not one of the prohibited grounds for discrimination in the Federal Constitution and in the Employment Act. Hence, there is little or no protection against discrimination faced by persons with disability in the workplace. The Persons with Disability Act contains no provision for enforcement. D, the government has not required employers to adopt regulations for protection against sexual harassment at the workplace. Presently, the legal framework for equality that defines discrimination and binds public and private sector and persons is inadequate. There is no standardized law, standalone law on sexual harassment, and the Employment Act does not adequately define discrimination in the workplace, nor does it prohibit discrimination. There are only procedures for addressing discrimination when it occurs. Women face trauma and fear and face immense stress because of victimization, harassment, or bullying and job insecurity. The sports coach states the harassment made her reserved and scared to speak or interact with people. Decriminalization of sex work is not a reform priority of the state, yet this has a positive impact in reducing stigma and violence against sex workers. Corruption and impunity by law enforcement agencies and other state actors increase access to healthcare and reduce prevalence of HIV, among others. The state has failed to make the lived realities of sex workers central to developing a constructive evidence and human rights-based response to the multiple forms of discrimination and violation they face. This includes the failure to address the structural inequalities and systematic exclusion that produce the cycles of exploitation and violence. Finally, recommendations. Number 1, eliminating harassment and violations at work. The capacity of labor departments must be developed to monitor and act against companies and employers that engage in exploitative labor practices. B, legal aid must be made available to workers to file complaints against companies that indulge in unfair labor practices. C, police abuse of sex workers must be stopped and police protection given to sex workers against exploitation and abuse by clients, pimps, and brothel owners. D, NGOs need to raise the issue of harassment and violations of women workers with the UPR process, the CEDAW committee, and at the Human Rights Council, now that Malaysia has a seat on the Human Rights Council. Number 2, the upward mobility of women in the labor market must be enhanced. We must advocate for enhancement and upward mobility of women's labor force participation. The ideology of sex stereotyping needs to be broken and job segregation eradicated. Further, the policy of fair remuneration, also known as equal pay for work of equal value, must be put in place, even if women are holding jobs seen as women's work. This has to be an aim. The government must create diversity of job opportunities for women, especially in non-traditional fields, and include this as a goal in their 5-year Malaysia plans. Number 3, there must be legal reform and institutional transformation. Discrimination must be defined and prohibited in the Employment Act. B, discrimination and violations in all its forms and against all groups of women must be monitored and prohibited. The Gender Equality Act and the Sexual Harassment Law must be speedily adopted. Disability must be made one of the prohibited grounds for discrimination in the Federal Constitution and in the Employment Act. The Persons with Disabilities Act must have provisions for enforcement. Sex work must be decriminalized in line with the CEDAW Committee General Recommendation number 35 on gender-based violence against women. This must be accompanied by ensuring that those in the industry have labor rights and access to basic services rather than rely on a rescue and rehabilitate approach. Next, international obligations. The government must develop a concrete plan for the implementation of CEDAW's 2018 concluding observations through a multi-sectoral mechanisms. Key relevant ILO conventions need to be ratified. One of them is Convention number 111, Discrimination in Respect of Employment and Occupation. Convention 190, Violence and Harassment in Workplace, 2019. Finally, other international human rights treaties to be ratified: the International Covenant on Economic, Social, and Cultural Rights, and the International Convention on Civil and Political Rights. Thank you very much.
Thank you, Shanthi. Moving on to the following presentation, I now invite Zainah Anwar to present her findings on contract workers. You may start, Zainah.
Thank you very much, Grazele. I will deal with the specific issue of discrimination against contract workers, the particular case of hospital cleaners. The exploitation and discrimination against hospital cleaners have been going on since the mid-1990s. Under the privatization of hospital support services, they lost their jobs as government employees and were treated as contract workers employed by companies that were awarded these cleaning concessions by the Ministry of Health. Unlike other workers with permanent employment contracts, these workers are given fixed term contracts which come with minimal worker benefits. Overnight, their salaries were reduced to minimum wage. They lost their job security, their wage increments, and allowances for shift work, night work, hazardous work, transport, and housing. They lost access to loans for housing, cars, and education for their children. The gravest injustice done to them under the contract work system is to treat each and every one of them as a new worker upon re-employment for another fixed term, which can range from 6 months to 3 years, depending on each concessionaire's contract. This is a fiction used to enable profit-making companies to evade benefits and protections due to permanent workers and to continually exploit the most vulnerable group of B40 workers, women, many of them single mothers with minimal formal education and little skills. And so today, we see hospital cleaners who have worked non-stop in the same hospital for over 20 years, still getting paid the minimum wage of 1,200 ringgit a month, the same as a new worker who has just been employed for the first time. This exploitative conduct of the concessionaires leaves the workers in perpetual poverty and in debt. Many complain by the 10th of the month, they have to obtain a loan in order to survive and maintain their family. The organizing and agitation against these terms and conditions of work have led to union busting tactics by the concessionaires. Our witnesses, Saras, Rosia, and Tarani, complain workers receive threats that include loss of job, overtime, and shift work should they join the union. They're pressured to withdraw the many complaints made to the Labor Department. Union leaders are punished with arbitrary transfers to hospitals far from their homes, made to work in 2 or 3 different locations in one day, and are denied overtime work. The National Union of Workers in Hospital Support and Allied Services has taken 4 court cases against UEM Agenta, a GLC company, a government-linked company, which holds the concession for the Northern Zone, covering 32 hospitals and clinics in Perak, Penang, Kedah, and Perlis. 3 cases are still going through the court process on union busting, enforcing a collective agreement, and an appeal to reinstate 6 workers whose services were terminated. The union lost the 4th case for overtime claims, originally filed by 108 workers from 10 hospitals. 74 workers withdrew allegedly because of pressure from the company. The rest lost their case, while only one won. So in spite of years of agitation, the exploitation suffered by these workers has not been addressed in any serious manner, either by the government or the concessionaires to stop the abuse. There is a clear lack of political will to find resolution to the ongoing problems. This continued gross neglect of workers' rights is not least because they are mostly women who are vulnerable to abuse due to their poverty, low literacy, lack of formal education, and lack of skills. The government, in outsourcing hospital support services to private sector companies owned by the GLCs, can be accused of complicity in the blatant violation of labor rights and exploitation of the hospital cleaners. It is within the government's powers in awarding concessions to require that concessionaires include and abide by certain fair and reasonable conditions and standards in employing workers to carry out these concession works. Zainah National, as the sole owner of UEM, the parent company of UEM Agenta, is also in a position to require, or at the very least scrutinize, whether employment policies and practices of the corporations under their control abide by fair and reasonable standards. The union busting tactics of UEM Agenta constitute a denial of rights under the Industrial Relations Act 1967 and ILO Convention 98 on the right to organize and collective bargaining, which Malaysia has signed. The denial of salary increment, non-recognition of experience and seniority, granting them fixed-term contracts when they are actually undertaking work of a permanent nature, directly undermine workers' right to livelihood and to lead a life of dignity. They are paid the minimum wage of 1,200 ringgit per month, irrespective of their length of service. The union calls a treatment of about 50,000 hospital cleaners, some 85% of them women, akin to modern slavery, and the resultant endless cycle of poverty and debt turns them into bonded laborers. Now I present to you the recommendations of the Women's Tribunal on this issue. The Ministry of Health must take immediate steps to ensure that it awards concession agreements under its hospital support services program only to contractors which set fair working terms and conditions for the cleaners. This includes setting decent pay above the poverty line, recognition of long service in setting remunerations and benefits, and recognizing the right to organize free from intimidation, to belong to a union, and the right to collective bargaining. The Ministry of Health should introduce a clause in the tender document demanding these terms, and that a company's failure to comply with social and statutory obligations opens it for inspection and penalties for breach of contract. Second, the Ministry of Human Resources and the Ministry of Health must take immediate steps to establish regulations that hospital cleaners under fixed-term contracts receive salaries and benefits in accordance to their length of service. The exploitative tactic of treating each worker as a new worker with each re-employment contract must be stopped. 3, Zainah National and GLCs under its control must demand and compel the enforcement of exemplary employment standards from its subsidiary companies. They cannot be allowed to engage in union busting activities, victimize transgender women organizers on the basis of their gender identity, and set exploitative work conditions in the pursuit of profits. 4, the Ministry of Human Resources need to take punitive steps to ensure that employers engage in contract labor accord fair rights and protections. It must put a stop, an immediate stop, to union busting activities and blacklist companies that engage in such blatant illegal activities to exploit workers. 5, the Ministry of Human Resources must immediately establish a tripartite social dialogue mechanism involving the Ministries of Health and Human Resources, the hospital services concessionaires, and the union to take a proactive approach to transforming labor relations in the hospital cleaning sector. The concessionaires should consider developing a decent work program for the sector in consultation with the union and with technical support from the ILO. For this to work, it is important that labor officials, employers, and unions are trained with the requisite knowledge and skills to engage in effective negotiation and social dialogue. Number 6, at the medium-term level, amend the Employment Act to establish and protect the legal rights and working conditions of this huge group of low-wage and vulnerable contract workers that include cleaners, not just in hospitals, but also in government buildings and schools and security guards. First, there is a need to establish thresholds for when contract labor should actually be prohibited. Several court decisions have already provided guidelines to determine whether a contract is a genuine fixed-term contract or actually a permanent contract. A contract of employment which is renewed successively without application by the employee and without any intermittent breaks in between is in reality a permanent employment. This clearly applies to the hospital cleaners who demand that the fixed-term contract system for what is in effect a necessary and perennial work within the healthcare system be abolished. It is obvious that their continuous employment, sometimes stretching for over 20 years, makes them in effect permanent employees. The fixed-term contract forced on them is nothing more than a fig leaf to enable the concessionaires to exploit this vulnerable group of workers by denying them salary increases, benefits, and protections entitled to permanent employees. Based on the guidance provided by the courts and in accordance with international standards, these hospital cleaners are in effect permanent employees and should therefore be absorbed into permanent service of the Ministry of Health and be accorded the same benefits and protections as accorded to all other Ministry of Health employees without discrimination. Second, establish terms and conditions for contract workers to provide job security, guaranteed annual wage increment, fair work practices, and protection of labor rights. They should explicitly establish a decent minimum wage, continuity of employment, even when the contractors change, and the contractors do change, guarantee of annual salary increments, holidays, hours of work, sick leave, occupational safety and health training, and benefits, and other conditions of service commensurate with seniority and scope of responsibilities. Offer job security through permanent work to long-serving workers upon the expiration of 2 contract renewals. And finally, recognize the right to freedom of association and to collective bargaining and continuity of collective agreements, even if there is a change of contractors. In conclusion, this abuse and exploitation of hospital cleaners have been going on for over 20 years. Many reports have been made to document their plight and to examine the beneficiaries of government services contracts covering cleaners and security guards under the privatization policy. The lack of transparency in the procurement process, the absence of demands for decent labor standards in tender documents, the contracts awarded to GLC-linked companies and politically connected individuals all point to explaining why there is a lack of political will to address the gross exploitation of workers who are, in fact, at the bottom 10% of the economic ladder. Instead of reaching mutually beneficial agreement on labor standards to protect the interests of all sides, it is the interest of the profit-making concessionaires that continues to be protected. This must stop. The power to stop this is in the hands of the government. First, by demanding that decent terms and conditions of employment be part of any contract awarded. Any breach will result in termination of contract and the contractors are to be blacklisted. Second, by establishing thresholds beyond which fixed-term contract work will be abolished and these workers be absorbed into permanent employment. Thank you.
Thank you, Zainah. Please stay on for your next presentation. Zainah Anwar will now present on the theme of domestic workers. You may start.
Okay. Thank you, Grazele. I will now present to you the findings and recommendations on rights of domestic workers. What are the issues of concern? The abuse and exploitation of domestic workers in Malaysia are well documented. Whenever the severe abuse or death of a migrant domestic worker comes to light, a public uproar erupts and bilateral relations are jeopardized. This then leads the government to propose regulations to tighten protections and rights of domestic workers. But once media attention on ill treatment of domestic workers die down, the political will to bring change also dies with it. We're talking about the lack of political will again and again and again. The back-breaking, endless, and repetitive labor of domestic work is not considered work, whether it is done by an employee or the wife, mother, sister, aunt, or any other woman in the family. It is this prevalence of gender stereotypes within our patriarchal society that leads to the exclusion of domestic workers as workers under the Employment Act. They are in fact regarded as servants, denied of rights. As our witness Minambal reported, they are denied job security and basic labor rights such as fair wages, regulated hours of work, rest days, holidays, sick leave, maternity benefits, and other work conditions and benefits which other workers enjoy under the Employment Act. The law limits a regular working week to 48 hours with maximum 8 working hours per day and 6 working days per week. These, however, do not apply to domestic workers, especially those who live in, nor does the law on minimum wage apply to them. Even when regulations and protections exist, for example, through bilateral memorandums of understandings between the source country and Malaysia, compliance level is low because of social attitudes regarding domestic work and domestic workers. A 2016 ILO research found domestic workers in Malaysia work the longest hours in the world, an average of 14.62 hours a day, with Indonesians and Cambodians working the most excessive extra hours. While most live-in domestic workers are paid above the minimum wage of 1,200 ringgit, when the numbers of hours of work are taken into account, this no longer holds true. The ILO study found that since domestic workers in Malaysia work some 14 hours a day, their minimum wage should be about 1,599 to 1,906 monthly, depending on how many days are worked. But 92% of workers earn 1,600 or below. These domestic workers are not paid overtime. Only 20% reported they would be paid extra if their employers held special events into the night. Setting boundaries between working hours and rest hours is a particular challenge for live-in domestic workers, given the personal context of their workplace. Restrictions in movements make it difficult for them to access their days off. Most domestic workers are unhappy over the lack of control over their rest period, which employers do not see as an essential part of the workers' well-being. They feel since their domestic helpers are not working fully during an 8-hour period, the extra hours are justified. But workers feel the fact that they are on standby to respond to the needs of their employers does not constitute real rest. The model of treating domestic workers as part of the family is often problematic. It leaves workers open to abuse as their status as workers is not recognized. Domestic workers may, for instance, give up important contractual rights, including minimum wage, right to association, to rest and off days, in return for an ill-defined and subservient relationship that often results in long working hours and poorly defined tasks. What are the rights denied and state failure in this case? The gross lack of rights and protections for domestic workers in Malaysia has exposed them to abuses that tantamount to forced labor. The ILO has established a set of 11 indicators of forced labor. These indicators represent the most common signs or clues that point to the possible existence of a forced labor case and can be used by law enforcement officials, labor inspectors, trade union officers, NGO workers, neighbors even, and others to identify persons who are possibly trapped in a forced labor situation and who may require urgent assistance. These indicators are abuse of vulnerability. Yeah, a worker might be of a different religion, a different ethnicity, doesn't speak the language of the employer, makes her vulnerable to abuse. Deception. When a worker is recruited under false promises, we hear this all the time. Isolation. When a worker's means of communication, like a handphone with family or friends, is confiscated. Restriction of movement. When a worker is not free to enter or exit the workplace on her rest day especially. Physical and sexual violence, retention of identity documents, another common complaint, intimidation and threats, withholding of wages, debt bondage, where the worker owes money to the employer and has to work indefinitely to pay off the debt, abusive working and living conditions, and excessive overtime. All the above are commonly heard and documented forms of abuse of domestic workers in Malaysia. The most egregious forms of abuse were inflicted on our witness, the late Adelina Lisau, who died one day after she was rescued from her employer's home. Her injuries were so severe that fluid dripped onto the hospital floor. She lived in great fear of her employer that she would not accept food or drink at the police station or the hospital without their permission. Neighbors who could hear the employer screaming at Adelina and saw her sleeping outside with the family dog tried to directly help, but could not, as Adelina was too fearful to speak up. The autopsy report showed that Adelina had a swollen face, dog bite marks, and acid burns, and she died due to multiple organ failure caused by anemia. What are our recommendations? Whether domestic workers are regarded as part of the family or as an employee, there is an urgent need to take immediate steps to stop the abuse and disempowerment and to establish fair and just working and living conditions and employment relationships. For a start, the government is due to amend the Employment Act 1955 to change the term domestic servants to domestic employees to entitle domestic workers to rights and protections enjoyed by other workers. The government has also announced that starting from June 1st, 2021, this year, domestic workers would be covered under the Employees Social Security Act and Employment Insurance System Act. This is important as SOCSO provides protection to workers against accidents and occupational ailments arising from their employment. However, since then, the Labour Department has stated that SOCSO coverage will not apply to local domestic workers like our witness Minambal, who work in several homes as they are considered self-employed. Given the perilous working conditions of domestic workers in Malaysia, more substantive steps to protect their rights need to be urgently taken. Number one, strengthen and implement the guidelines and tips for employers of foreign domestic workers produced by the Ministry of Human Resources in 2017 with the support of the ILO. It already exists, implement it, strengthen it. It is critical that employers recognize their relationship with the domestic worker is and foremost a professional employer-employee relationship. This means a contract of employment is needed to establish clear terms and conditions of work with the full knowledge and agreement of the worker. Employers should establish mutually beneficial working conditions that include tasks, job scope, working hours, weekly rest day, salary and other remuneration, a comfortable room with privacy, an option to live in or to live out, and home leave, insurance coverage, and other rights. Number two, given the excessive long hours of domestic workers in Malaysia, implement an immediate daily rest period and weekly off days. Number three, the embassies of source countries should take more proactive steps to protect and represent the interests of their citizens in Malaysia by negotiating and updating the MOUs with the government with fair and just terms condition of work. Such negotiations should involve workers' representatives and NGOs in source countries putting pressure on their governments to set better terms and conditions. The MOU signed with the Philippines government and the support provided by the embassy in Kuala Lumpur and peer group and church support among Filipino domestic workers provide them with better treatment and protection compared to those from other source countries. Provide a weekly space and time where domestic workers can gather and report any violation of rights and protections. 4, establish a mechanism and procedures for the investigation of complaints, alleged abuses, and fraudulent practices concerning the activities of private employment agencies. We hear this all the time, yeah? As recommended by the CEDAW Committee in 2018, domestic workers should also have access to effective remedies and redress against abuse by employers. This mechanism should be established by the Labour Department working with the embassies of source countries and workers' rights groups. In the medium term, number 4, establish a tripartite social dialogue. This basic mechanism for dialogue on all kinds of workers, different workers who face abuses and systemic exploitation need to be established. The emphasis on legal approach and regulations to protect the rights of workers must be accompanied with a process of social dialogue that includes the participation of both employers and workers' organizations, as well as domestic workers to extend rights and protections and facilitate collective bargaining. NGOs can provide training, advice, and support to help domestic workers organize to build their own voice and representation in social dialogues where they can reach common agreements in linking their interests with that of their employers. It is also important to raise the awareness of full-time domestic workers, their option to live in the employer's house or away from the household where they work. 5, amend appropriate laws and regulations to enable migrant domestic workers with court cases to stay on in Malaysia without being declared as undocumented people and having to apply for special permits and pay fees. They also must be protected from harassment or threats from their former employers or the authorities. 6, comply with international standards. Given the continuing and growing need for domestic workers in this country and the stories of abuse and exploitation and forced labor conditions, we urge the government to immediately ratify 2 key ILO regulations. The ILO Domestic Workers Convention number 189, adopted in 2011, that long ago, which recognized domestic workers as workers, and the ILO Forced Labor Protocol, adopted in 2014, which requires member states to take effective measure to prevent forced labor, protect victims, and ensure the access to justice. Finally, in the long term, enact a Domestic Workers Employment Act. Since 2017, advocates for domestic workers have been calling for a specific law to protect the rights of this group of vulnerable workers. A draft bill was drawn up by Tenaga Nita and several other NGOs, setting up a list of rights and protections, including minimum wage, normal hours of work, days off, rest period, annual leave, provision of food, accommodation, and decent working and living conditions, terms and conditions on termination of employment, medical insurance, and other treatment and medication to be borne by the employer, the type of work performed by, and the responsibilities of a domestic worker, freedom of movement, and freedom of association. The government needs to engage with NGOs and domestic workers groups to negotiate for such a legislation or to amend the Employment Act to protect the rights and welfare of domestic workers. We understand that enacting a new piece of legislation takes time. We urge the government then to immediately implement, as suggested in number 1, the guidelines and tips for employers of foreign domestic helpers, which already exist, and meet immediately with advocates for domestic workers to work out the practicalities of effective application and monitoring. Thank you.
Thank you for your presentations, Zainah. I now like to invite the following judge, Nadia Malayanah, who will present her findings on citizenship. Over to you, Nadia.
Thank you, Grazele. I will now present the tribunal's findings and recommendations on the issue of citizenship. The 3 witnesses that was affected by this issue are Jennifer and Mepgo, who are children of Malaysian mothers, and Priscilla, who is a Malaysian mother with non-citizen children. I will now go on to present the issues of concern. Little has changed for Malaysian mothers and their foreign-born children in terms of citizenship rights. Despite multiple changes in government over the last 3 years, since the submission of Malaysia's last UPR report, Malaysia continues to be one of the 25 countries denying women equal rights to men in conferring citizenship to their children due to the current provision in the Federal Constitution. On the other hand, Malaysian men married to foreign spouses whose children are born abroad are automatically considered conferred Malaysian citizenship should the child's birth be registered with a Malaysian consulate or the Malaysian government within the stipulated period under Article 14, Clause 1B via operation of law. Currently, any Malaysian woman who wishes to confer their citizenship to their children born overseas would have to apply to do so via Article 15, Clause 2 of the Federal Constitution as outlined in provisions of subclauses 1B and C of Part 2 of the second schedule. The continuous cycle of closure and reopening of international borders as well as the various movement control orders, or MCO, imposed in Malaysia due to the COVID-19 pandemic since February 2020, have also created additional hurdles for these mothers and their children. These include having to make difficult decisions regarding flying back to Malaysia due to the stateless status of one's child, the difficulty in acquiring long-term visas for non-citizen husbands and children, as short-term visas were unavailable, vulnerability to domestic violence from non-citizen husbands, and the inability to access government aid, as well as public health care for their non-citizen children. On 18th of December 2020, 6 Malaysian mothers, together with Family Frontiers, filed a lawsuit via an originating summons against the Malaysian government, which is also known as the Family Frontiers case. Suryani Kempe, in her capacity as President of Family Frontiers, stated that the citizenship application process provided by Article 15, Clause 2 was not only lengthy, but often rejected, as quoted, as the conferment of citizenship is subject to the discretion of the minister. Before heading to court, these 6 mothers have previously attempted to apply citizenship for their children via Article 15, Clause 2. Some mothers have had their applications rejected with no reasons provided for these rejections, while some continue to wait for a decision of their most recent attempts from the government. However, the Malaysian government applied to have this case struck out of court without being heard on 22nd January 2021, which was then rejected by the High Court on 6 May. Aside from allowing the case to be heard, the court also allowed the Home Minister and the National Registration Department's Director General to be added as defendants. On September 9 the same year, High Court Judge Dato' Akhtar Tahir issued a landmark ruling which recognized that Malaysian women should be granted the same rights as Malaysian men in passing on citizenship automatically to their children born overseas. He also ruled that Malaysia's citizenship laws in the federal constitution should not be interpreted in a manner discriminatory to Malaysian women. He then issued 3 court orders in favor of these mothers, including a declaration that the word father in subclauses 1B and C under Part 2 of the second schedule to the Constitution be interpreted to include the mother, which meant the children were now entitled to citizenship by operation of law under Article 14, should all procedures be followed accordingly. The other court order was for the government to extend the time for these mothers to comply with the necessary procedures. With the third and the final order is for the authorities to issue the relevant documentation to effectuate the declaration of the court. However, a few days later, on September 13, the Malaysian government, Home Minister, and the National Registration Department Director General filed an appeal against this historic court decision. On September 14, they also filed an application at the High Court to stay or temporarily suspend part of the High Court's decision until the Court of Appeal decides the appeal. This came as a surprise as there was publicly expressed support for the court decision from 3 federal ministers, including the de facto law minister, Datuk Sri Wan Junaidi Tuanku Jaafar. On November 15, the High Court rejected the government's stay application. It should also be noted that prior to the Family Frontiers case, Wan Mahisha Sulaiha filed a lawsuit via an originating summons against the same 3 parties on 2 November 2019 to seek declarations, including that she is a Malaysian citizen based on constitutional provisions, and as her mother is a Malaysian, to seek for a Malaysian identity card and citizenship certificate to be issued to her. On 21 May 2020, the High Court rejected her suit. Mahisha then filed an appeal to the Court of the Appeal. On November 2, 2021, it was decided that both the Family Frontiers case and the Mahisha Sohaila case would be heard together in the Court of Appeal to avoid overlapping or conflicting legal decisions. Malaysia has continued to place reservations to CEDAW Article 9, Paragraph 2 and CRC Article 7, which concerns citizenship and nationality. While Malaysia has recently acquired a seat on the United Nations Human Rights Council with an overwhelming majority, the current government has not made any clear indications on potentially lifting these reservations. As of November 2021, de facto law minister Wan Junaidi Tuanku Jaafar stated that the Conference of Rulers would be briefed on the current legal dispute over the citizenship of children born overseas to Malaysian mothers. Any proposal to amend the current constitutional provisions on citizenship would require the ruler's approval and possibly that of the governors of Sabah and Sarawak, as well as parliamentary approval by a 2/3 majority. Information concerning the number of citizenship applications under Article 15, Clause 2, and the status of these applications can be difficult to ascertain, save for these numbers retrieved from parliamentary proceedings. In a written parliamentary response to MP Bukit Gelugor Ram Karpal Singh on 26 October, the Home Ministry wrote that there were a total of 2,352 applications made by mothers who are Malaysian citizens based on the National Registration Department's records from 2018 until October 11, 2021. While it was also stated that 21 applications were granted citizenship and 31 applications were rejected, the status of remaining applications remain unclear. The Home Ministry, in a similar written reply on 20 March 2019, had previously stated that the National Registration Department had received 4,112 citizenship applications under Article 15, Clause 2 of the Federal Constitution from the year 2013 to 15 February 2018. Prior to these written replies, it was recorded in the Hansard that a total of 142 citizenship applications under Article 15, Clause 2 have been approved between the years of 2013 to 2018, whereas a total of 2,253 citizenship applications under the same provision were received by the National Registration Department for the period of 2018 up to 15 September 2019. This data, along with case studies gathered via the Women's Tribunal, illustrates that the current citizenship by registration process has not worked out fairly or equitably for Malaysian women and their children. Mothers are often subjected to this onerous process at great financial and emotional cost to themselves and their children, only to end up waiting for years in silence for an eventual rejection. I will now go on to the second part of this presentation, which is rights denied and sentence not adhered. The right to citizenship is one of the fundamental rights in any democracy. The Federal Court, in its recent decision in CCH and ADY versus Pendaftar Besar, bagi Kelahiran dan Kematian Malaysia stated that citizenship, no doubt, is governed by Part 3 of the Federal Constitution, but it is also a concept so so linked to the right of life and personal liberty contained in Article 5, Clause 1. As such, any provisions on it must be construed as widely as possible. The right to citizenship is made even more critical in Malaysia because other fundamental rights and liberties guaranteed by the Federal Constitution are in fact conditional upon citizenship, including the right to equality under Article 8, Clause 2, right to freedom of movement under Article 9, right to freedom of speech, assembly and association under Article 10, as well as right to education under Article 12. Jennifer and Mapung are denied their birthright to be declared as Malaysian citizens despite being born to Malaysian mothers. And this denial has directly shaped their life choices. Both also share the similar predicament as being the only family member and child to not possess Malaysian citizenship, which impacts one's access to basic services, including crucial life-saving healthcare for Mapung, and in Jennifer's case, one's right to legally remain in Malaysia with one's family. The denial of these rights also comes with great emotional, financial, and personal costs for Malaysian mothers and their children who are directly affected. The denial of her children's citizenship caused Priscilla to rely heavily on education visas acquired via admission to international schools for her children to be able to remain in Malaysia. This admission is directly caused by the inability to enroll her children into national schools due to their status as non-citizens, and the failure to maintain her children's education might have an impact on her custody rights. But this is placing an extremely heavy financial burden on her, especially when her job has been directly affected due to the pandemic. Previously, Priscilla had to rely on regular visa runs to ensure her children would be able to remain legally in Malaysia. Similarly, Jennifer is currently reliant on her student visa as a postgraduate student to continue staying with her mother and sister in Malaysia, who are both citizens. For this purpose, she has had to enroll in a private university. As her visa is set to end next year and the status of her citizenship application is currently unknown, it is very likely that she would have to return to her estranged father's home country alone without any familial support. I will now go on into the recommendations, which are all short-term and should be implemented within 1 year. Firstly, the Malaysian government must provide safeguards for children awaiting citizenship approvals without prejudice in the form of a long-term social visit pass, and eventually permanent residence. Secondly, regular training should be provided to embassy, immigration, and national registration department staff on procedures and policies concerning citizenship, as well as to foster sensitivity towards challenges faced by Malaysian women and their non-citizen children. The National Registration Department should also provide regular updates to citizenship applicants on the progress and the status of their applications, as well as clarification upon rejection. The government must also immediately review and solve issues concerning visas of non-citizen children of Malaysian mothers. Next, the Malaysian government must withdraw the appeal filed at the Court of Appeal regarding the September 9 Kuala Lumpur High Court decision and immediately implement the court order issued. The Malaysian government must also lift its reservations to Article 9, Clause 2 of CEDAW and Article 7 of CRC. Finally, and most importantly, the government must amend subclauses 1B and C of Part 2 of the second schedule of the Federal Constitution to include mothers, enabling women to confer citizenship on children born overseas on an equal basis as men. This is to be done by replacing the word father with the phrase parents one at least for the Constitution to be read inclusively. Thank you.
Thank you, Nadia. I now invite Shanthi Dairiam to present her findings on unilateral conversion. You may start, Shanthi.
Okay, thank you, Grazele. I'm going to speak to the situation of Indira Gandhi, who has been severely affected by the unilateral conversion of her children and the kidnapping of her youngest born child and separated for more than 11 years from the child. This is a complex case involving conflict of civil law and Islamic law jurisdictions brought about when a Hindu husband, Padmanabhan Lalaki Krishnan, converted to Islam and took on the name of Muhammad Ridwan bin Abdullah. He subsequently unilaterally converted all 3 children from the marriage to Islam without their mother Indira Gandhi's knowledge or consent. Further complications ensued as a result of him forcibly taking away the youngest child, Prasanna, who was 11 months old, from the mother and disappearing. Now, there are several issues of concern with this case. The first is kidnap and separation of mother from child. Prasanna, an 11-month-old female child, was kidnapped in 2009 by the husband, separating the mother, Indira Gandhi, from her breastfeeding infant. In spite of several court cases filed by Indira to recover her child over a period of 12 years, her quest to be reunited with Prasanna has not been successful. The next issue of concern is unilateral conversion of all 3 children who were minors at that time. On converting to Islam, Ridwan unilaterally converted all his children without Indira's knowledge. Indira petitioned the civil courts in 2013 to quash the unilateral conversion of her children and obtain custody of them, and was successful. Finally, after a period of 5 years, in January 2018, the Malaysian Federal Court issued a unanimous decision in favor of Indira Gandhi, voiding the children's certificates of conversion. Unilateral conversion of minors to Islam, besides being unfair to non-Muslims, entrenched inequalities in Malaysia and does so in the name of Islam. Next issue of concern is court orders have not been complied with. Indira Gandhi had obtained a custody order of all her children from the High Court in 2010. And on the basis of this, a 2014 High Court order had been issued to Ridwan to return Prasanna, the youngest child that he had snatched, to the mother. He did not comply with his order with impunity and has been held in contempt of court. I next go on to look at rights violated because of this situation. First of all, Indira Gandhi has been denied the right to equality and non-discrimination as a parent and guardian, equal guardian of her children as per the Federal Constitution, Article 8.1 and 2. In particular, she has been denied the right to custody of infant child and not to be separated from the child without cause. She has been denied the right to equal guardianship of her children as per the Guardianship of Infants Act 1961, and the equal right to make decisions regarding the religion of her children. The trauma and anguish Indra has faced due to being separated from her infant daughter from 2009 to 2021 is a gross human rights violation. In Malaysia, it is virtually impossible to convert out of Islam. The Convention on the Rights of the Child requires status quo of a child's religion until he or she turns 18 for the child to decide. If parents convert a minor into a religion which under Malaysian law does not allow one to convert out, it is an additional human rights violation for that child. Now I speak to standards that have not been adhered to and the failure of the state in this whole situation. First of all, at the national level, there's a breach of the Child Act 2001. According to provision 52 of the Child Act, it's an offense to take the child away without consent of the one who has lawful custody. In Indira Gandhi's case, the recovery order issued by the Court of Appeal in 2015 has not been complied with by the police. According to the Guardianship of Infants Act 1961, revised 1988 and section 5.1 in relation to custody, the mother shall have the same rights and authority as the law allows to a father, and the rights and authority of the mother and the father shall be equal. However, Indira's children were converted to Islam by the religious authorities of this country without her consent, in defiance of this act. Best interests of the child has been violated. The Guardianship of Infants Act, section 11, the court or a judge in exercising the powers conferred by this act shall have regard primarily to the welfare of the infant and shall, where the infant has a parent or parents, consider the wishes of such a parent or both of them as the case may be. The other standard that's been violated is there's a 2018 federal court ruling that unilateral conversion of children is illegal. Overall, the right to equality, Article 8.1 of the Federal Constitution, guarantees of equality of all and equal protection of the law, and 8.2 of the Constitution, non-discrimination, in this case of Indira Gandhi, has not been adhered to with, and I would say with impunity. Now, what are the international standards also that have been disregarded or disrespected? The principle of the best interest of the child is a primary principle in the Convention on the Rights of the Child, and Malaysia is a party to this convention. Article 3 says the best interest of the child will be a primary consideration. CEDAW Article 16.f says equal guardianship of both parents are legitimate and in all cases, but the interest of the children will be paramount. In the Convention on the Rights of the Child, Article 9 says state parties shall ensure that a child shall not be separated from his or her parents or against their will, except if necessary for the best interest of the child. I come to a very important section now, which is how has the state failed in all of this? First of all, a dual legal system governs Muslim and non-Muslim personal laws separately, and Article 12(1)(a) of the Federal Constitution excludes the civil courts from hearing matters relevant to the Sharia court or if involving Muslim parties and vice versa. This interpretation of Article 1(a) of the Federal Constitution is questionable. It has created much difficulty for parties, especially in cases when a husband converts to Islam. The conflicting jurisdictions have the far-reaching effect on guardianship, custody of children, maintenance of the house that is not converted, the religious conversion of children, inheritance, and funeral rights of the deceased spouse. The conflict in jurisdiction is detrimental in many ways and must be resolved. CEDAW's concluding observations of March 2019 in paragraph 54 states, the committee reiterates its previous recommendation in 2006 that the state party undertake a process of law reform to remove inconsistencies between civil law and Sharia law, including by ensuring that any conflict of law with regard to women's rights to equality and non-discrimination is resolved in full compliance with the Constitution and the Convention. And I emphasize, the state has taken no such action since 2006 to resolve the conflict in jurisdiction between the civil and Sharia systems, since it was raised by the CEDAW committee at that time. In particular, the CEDAW committee also recommended that the state party prohibit the unilateral religious conversion of children to Islam by a father who converts to Islam. B, the ambiguity of Article 12.4 of the Constitution, which states that the religion of a person under the age of 18 shall be decided by his parent or guardian. Now, Article 12.4 is subject to interpretation, and this does not answer the question of whether it is either parent or both parents, leaving it open for one parent to convert the children unilaterally. Not rectifying this anomaly is a failure of the Malaysian Parliament. C, failing to amend the Law Reform Marriage and Divorce Act. The Law Reform Marriage and Divorce Amendment Bill was tabled for first reading in November 2016. The bill included a new section 88A, which addressed unilateral conversion. The bill passed Dewan Rakyat in August 2017 with the proposed section 88A removed. This is again a failure of Parliament. The law as it stands today is against a non-converting spouse like Indira Gandhi. Further developments with regard to conversions are, however, encouraging. In 2018, the federal court had unanimously ruled that the unilateral conversion of the 3 children of Indira Gandhi was null and void, holding that the consent of both parents was needed to convert a minor. This was a very important ruling of the court in 2018. D, a 2015 court order for a recovery order to find the kidnapped child's whereabouts has not been complied with by the police. They have failed to track down the husband and to penalize him for kidnap and for not returning the child to the mother. Shockingly, the IGP stated he could not comply because the husband has a Sharia court custody order. So there are 2 custody orders in conflict, one from the Sharia court favoring the father and one from the High Court favoring the mother. And the IGP said he cannot choose to give preference to one over the other. However, the High Court had held that the Sharia court's custody order is null and void, as the Sharia court had no jurisdiction to grant the said custody order. The issue is that when the executive, in this case represented by the police, refused to execute a High Court order, it leaves the public without a remedy and perpetuates the notion that the police is above the law. This is really serious for us here. I now come to recommendations. The IGP must carry out and enforce the pronouncement of the federal court in 2018 and to pursue the immediate return of Prasanna to her mother without delay. Number 2, it is imperative that Parliament reintroduces Section 88A, which had at the last moment been withdrawn from the Law Reform Marriage and Divorce Amendment Bill 2016 that was passed to amend the LRA in August 2017. Number 3, Article 12.4 of the Federal Constitution, which states that the religion of a person under the age of 18 years shall be decided by his parent or guardian, must be interpreted as requiring the consent of both parents, according to the federal court in 2018. This interpretation must be maintained in all future cases. It is advisable to amend the wording of the Federal Constitution, Article 14.4, to remove all ambiguity. Importantly, the government must seek sustainable, just, and consistent political and a legal solution to the issue of unilateral conversions, binding all states of the Federation and preventing anomalies and different standards of justice in different states. The solution must address ambiguities and conflicts in the law and civil versus Sharia jurisdictions, or these uncertainties will continue and the authorities like the IGP will likely refuse to act in any manner that might be seen as defying Islamic authorities, even if it means directly flouting a civil court order. And in the meantime, every new case that goes through the court is a gamble that the federal court decision in Indira Gandhi may be distinguished or superseded. Number 4, it would be ideal that the police force have a more fair representation of the various races in Malaysia in its composition, including in senior positions. Finally, in conclusion, having exhausted all avenues to challenge the custody order, Indira's ex-husband Ridwan willfully disobeyed it and refused to hand over the youngest child, Prasanna Diksha, to her mother. The ex-husband is able to act with such impunity because the police have also willfully defied the court order to trace his whereabouts and require Prasanna. Indira Gandhi's protracted legal battle finally reached the Malaysian Federal Court. Her case, which has been in the public eye for almost a decade, is emblematic of broader contestations over the role of Islam in the Malaysian state and the judicial authority of the civil courts in relation to the religious courts. An amicable solution for this is desperately needed. Thank you.
Thank you, Shanthi. We will proceed with the next presentation. Zainah Anwar will present her findings on right to equality in family laws and practices. You may start, Zainah.
Thank you very much, Grazele. Okay, I will now go to the long-standing difficulties Malaysian women face in assessing their rights under family law. This must be addressed immediately. Be it getting a divorce in the Sharia court system or obtaining adequate maintenance for their children in all 3 court systems, in civil, Sharia, or customary courts, women give up their rights or submit to threats and pressure in order to get out of a bad marriage faster. Many women in the end feel it is a waste of their time and emotionally draining to pursue their rights granted under the law within a patriarchal culture and what they see as a gender-biased, complicated, and costly court processes that they can't afford. The myriad of issues raised by our witness, Puan Nora, reflect the discrimination against women in Muslim family law, its impact not just on women's rights, but in perpetuating patriarchy justified in the name of Islam. There is still a common belief in the Muslim community that men are superior to women and that divorce is in the hands of men. This has led to many women thinking that they have no rights in Islam, nor under the country's Islamic family law. Puan Nora did not know that she, as a woman, has the right to initiate divorce on several grounds and that she has the right to a share of the matrimonial assets by virtue of her role as wife and mother. A most progressive provision in law that many women remain unaware of today because of this dominant misogyny and patriarchal culture in our country. The issue of non-payment and inadequacy of child support are common problems faced by women in civil, Sharia, and customary practices. Our witnesses, Puan Nora and Alia and Kolon in Sabah, and our advocates all complain of frustrations in trying to claim maintenance for children because of the numerous hurdles in their way. These include complicated legal procedures, lengthy and costly court processes, including cost of enforcement proceedings and delays in disposal of matters, the burden on the woman to prove the father's income and assets, the inadequate maintenance awarded, the absence of court guidelines to assess what constitutes fair and adequate maintenance for children, fathers' continual default in maintenance payment, and willful disregard of court orders that lead to an endless cycle of expensive court enforcement proceedings. The lack of enforcement, including delays in serving court orders. The burden placed on mothers to locate their defaulting ex-husbands. Court bias towards fathers, including ready acceptance of his excuses for inadequate or non-payment. Many women give up further education and a career to be a full-time homemaker and mother. They thus lose out in terms of financial independence. When the marriage breaks down, women's lack of financial resources to fight for their rights in court means women like Puan Nora, who was a full-time homemaker, is unable to hire a lawyer and meet court costs and other related costs in filing various claims. They feel discriminated against and disadvantaged as their husbands could hire the top lawyers that they could not afford. Other issues raised by our witnesses include domestic violence, rape within marriage, illegal customary marriage at age 15, abandonment, unresolved court claims for maintenance, and unfair treatment in a polygamous marriage. Now I turn to rights denied and state failure. Our witnesses face a whole range of denial of rights: right to equality under the law, right to non-discrimination, access to justice, right to maintenance, to areas in maintenance, right to the matrimonial home, and to a share of the matrimonial assets. For Muslim women in particular, the belief that Islam does not regard women as equal to men continue to be used to justify why law reform cannot take place to end discrimination against Muslim women. The rise of political Islam in Malaysia saw one of the most progressive Muslim laws in the world, Muslim family laws in the world, in the 1980s regress in the 1990s onwards towards amendments that chiseled away at the rights women had gained, and to make it worse, the introduction of new provisions that further discriminated against Muslim women. In the name of Islam, the government continues to maintain its reservations to Article 16 of the CEDAW Convention on Marriage and Family Relations and evade compliance with its treaty obligations. While the trajectory of law reform moved towards recognizing equality in the family for women of other faiths, for Muslim women, the reverse was happening. This deep-seated misogynistic attitude denies women access to justice, even when the law grants them rights. It was not until our witness, Puan Nora, approached the Sisters in Islam legal clinic that she found out about her rights in law that she had foregone when she submitted to her husband's demands and threats of losing custody of her children if she demanded her financial rights. Now I go to recommendations. The continuing discrimination against women in law and practice must stop. The Women's Tribunal recommends that the government undertakes the following actions to advance family well-being for all citizens in the country, not just men. In the short term, number one, take immediate steps to comply with the 2018 CEDAW concluding observations on Article 16, which, among others, call on the government to undertake a comprehensive law reform process to remove the inconsistencies between civil and Sharia law, to ensure Muslim women enjoy rights to equality and non-discrimination in all family and marriage matters. These include raising the minimum age of marriage to 18 for women, equal right to enter into marriage and to divorce, to maintenance, custody, and guardianship of children, and to inheritance. This reform process to end discrimination in the family should also extend to the customary laws and practices in the native courts of Sabah and Sarawak. Number 2, establish a family court legal service center. This is critical to address the lack of knowledge on existing law and procedure and the options available for women. The center should be staffed by trained personnel to provide free services, including legal advice, information booklets, various case application forms and procedure to enable parties to navigate the often confusing court processes at a time of conflict and distress. This also saves court time. In the medium term, we recommend the establishment of a fully functioning family court system to cover civil, Sharia, and customary law jurisdictions to enable family members to resolve disputes through conciliation and mediation, rather than a hostile adversarial court process. This is now a global trend where an approach that includes counseling and mediation is favored in resolving family disputes rather than a hostile judicial process. In such systems, over 90% of cases can be resolved through mediation, with only a small number of complicated and contentious cases being heard before a judge. A family court with specialist judges and professionally trained staff, especially mediators and counselors, can help couples reach more amicable decisions to promote family well-being and protect the best interests of the child. This more reconciliatory approach will particularly help women and children who are often intimidated by an adversarial process and thus give up their rights due to intimidation, lengthy procedure, and high costs. It will also create a better post-divorce environment where both parties can work towards co-parenting in more reconciliatory ways. Number 4, establish a federal level court support agency to assist parents to meet their responsibilities to ensure that every child within marriage or outside marriage is maintained. This is non-negotiable and non-disputable. Every single child must be maintained. The agency's primary task is to assess, review, enforce, and arrange for child support payments. Instead of mothers going up and down the courts repeatedly to enforce maintenance orders on recalcitrant fathers, it is the task of such a child support agency to trace and contact non-resident parents to collect and forward maintenance payments and to retrieve areas in maintenance as debts to the government. Payments can be made through direct deductions from salaries or bank accounts or other accounts of funds, seizure of assets, or restrictions from leaving the country. The agency also sets punitive measures for non-payment that can include non-renewal of passports, as in many other countries, business license or driving license. Fathers should no longer be allowed to get away with their bad behavior with impunity. The agency should also provide support to women who are still married to obtain maintenance for the family from irresponsible fathers who fail to provide regular or adequate maintenance. This is particularly so in polygamous marriages when fathers either can no longer afford to maintain children in multiple households, I don't know why they were allowed to get married again, or just abdicate their responsibilities by willfully not paying. Under the Islamic family law, actually, male relatives on the father's side can be pursued for maintenance when the father defaults. So this is another role that a child support agency can undertake under the law. In conclusion, it is really time for an upper middle income country like Malaysia take immediate steps to reform the substance and administration of its family laws to ensure justice for all and to promote family well-being. Research shows that many countries at the bottom of various gender equality surveys are those with family laws that discriminate against women. This has led to gender gaps in indicators such as educational attainment, economic participation and opportunity, health and survival, and political empowerment. For a country like Malaysia to be continually at the bottom half of the annual World Economic Forum Gender Gap Survey is embarrassing. But it is no surprise because several cross-country studies show that Muslim countries with discriminatory family laws dominate the bottom 25 of these tables. In fact, the 2019 World Bank study on women, law, and business finds Malaysia among the bottom 25 of worst performing countries. Another study using the World Bank data sets to measure women's legal capacity in 15 areas of their personal status found that discrimination in family law is significantly associated with women's labor force participation, ownership of assets, and ownership of bank accounts. In fact, they found that family law is the single biggest predictor of women's economic empowerment. Without equality in the family, there can be no equality for women in public life. Research findings are clear. Gender equality is good for the family, for society, for the economy, for a country's peace, prosperity, and well-being. It is time the government summons the political will to do what is right and what is just for 50% of its population and treat women as citizens and human beings of equal worth and dignity. Thank you.
Thank you very much, Zainah. We will now have a short break. When you come back, there will be 5 more presentations on education, rural health, violence against women, rights of trans women, young women in politics and public life. We also have a message from the Deputy Minister in the Prime Minister's Department in charge of Parliament and Law. We may go over lunchtime. We may finish at 1:30 p.m. So be sure to grab something to eat. And please come back at 11:45 a.m. Thank you.
Wow, we are 30 minutes.
everyone to the Women's Tribunal Judges' Findings and Recommendations. I hope everyone has had some time to move around or grab something to munch on. Thank you for still being with us. We are now at the second half of the event. We will continue to listen to 5 more judges' presentations on education, rural health, violence against women, rights of trans women, young women in politics and public life. And please do stick around till the end as we have a message from the Deputy Minister in the Prime Minister's Department in charge of Parliament and Law. We will continue. Without any further delay, I'd like to invite Nadia Malayanah to give her presentation on the theme education. Over to you, Nadia.
I hope everyone has had a good short break. I will now go on to present my next issue, which is education. However, we acknowledge that in the issue of education, there are a lot of sub-issues that can be dealt with. However, for the purpose of this tribunal, specific sub-issues that we will be dealing with are Orang Asli education, as well as the safety of schoolgirls in Malaysia. I will now go on to present the issues of concern. Malaysia has progressed considerably over the last 2 decades in terms of ensuring access to education for girls and women, as reflected in the high levels of literacy and educational attainment for Malaysian girls and women. However, it is very likely that this progress will be undone by the COVID-19 pandemic, as public health measures to curb infection rates, including hybrid learning, as well as repeated school closure and reopening, have had a disruptive impact on education in Malaysia. Marginalized communities, especially indigenous children, have experienced some of the more severe impacts of education disruption due to COVID-19, which amplifies the vulnerability of these children. Many Orang Asli children in Peninsular Malaysia and indigenous children in East Malaysia who lived in boarding schools or homes away from their families to study had to be sent back to their families at the start of the movement control order. Despite life going on relatively normally in these villages, the lack of internet access meant participating in online learning was not an option for children living in rural locations. This had caused many indigenous children to fall behind in their schoolwork and face challenges upon returning to face-to-face learning in their schools, as they essentially have lost formal education for nearly a year. Prior to the pandemic, education gaps between Orang Asli and non-Orang Asli children have continued to persist despite near universal literacy and school enrollment rates in Malaysia. Orang Asli students face 2 major struggles in school, namely high dropout rates and low level of academic attainment. Ministry of Education data from 2017 revealed that the dropout rates of Orang Asli students remained as high as 26% that year, despite the ministry's target to reduce this to only 8%. In contrast, the dropout rate for the national average in that same year was only 3.4%. Notably, the government has made attempts to institute several policies and initiatives aimed at tackling these education gaps, most notably via the Malaysian Education Blueprint 2021 to 2025. Specific initiatives geared to improve access and equity for Orang Asli students include the expansion of K9 schools from 2 to 6 schools, updating the contextualized curriculum Asli dan Penan, or KAP, to align with the principles and framework used in the Standard National Syllabus, or KSSR, and the establishment of a research center to develop curriculum and pedagogy tailored for the needs of children from Orang Asli and other minority groups. While Orang Asli student attendance have shown to improve, the transition rates of these students from primary to secondary level decreased, which is a reflection of how long-standing the education gap has remained. So the 4 testimonies of Orang Asli girls from different Orang Asli sub-ethnic groups, Rosita, Siti Fida, Noraini or Chipam, and Yaliana, reveal a shared experience of growing up in school hostels away from their families to acquire an education. These young women spend more time with their teachers and peers in an environment that may not be sensitive to their needs and is respectful of their cultural heritage as Orang Asli. Another common experience shared between these 4 young women is to have their culture and beliefs as Orang Asli be disrespected and stigmatized by peers and occasionally even by teachers. Stories of teachers attempting to purify young Orang Asli students by imposing certain religious practices are also alarmingly common within their community. Due to this, some Orang Asli girls and women might resort to leaving their identity and heritage behind or hidden in order to evade and minimize bullying and stigmatization as these women go on to pursue their studies to higher levels. The overall safety and well-being of girls and women in education institutions in Malaysia also continue to be a serious concern. While it is difficult to officially quantify the prevalence of sexual assault and harassment incidences in schools and universities, 770 anecdotal accounts received via Save the Schools Malaysia's Instagram page and a number of high-profile cases reported over the last decade are sufficient reminders as to how insistent and persistent this concern is. Such recent high-profile cases in 2021 include student activist Ain Husniza's TikTok expose of a rape joke allegedly made by her former physical education teacher. Media has also reported several sexual harassment cases involving public universities. A majority of the survivors coming forward recount incidences of verbal and sexual harassment in their submissions to Save the Schools Mind, including period spot checks, which is an invasive practice where a teacher or a student under the direction of a teacher checks whether girls are menstruating. Bullying from peers or other authority figures such as teachers and school staff also seem to be prevalent among these submissions, alongside a small number of survivors recounting incidences of rape, child grooming, and stalking. Unsurprisingly, survivors confide that their reports were regularly dismissed by authority figures and perpetrators are not reprimanded. They also receive backlash and are not supported after coming forward. And the overall school environment is deemed as not supportive or respectful of girls. Other long-standing issues concerning education, including gender gaps, in technical courses and higher education degrees, the accessibility of rural schools, which has now become more pertinent due to the pandemic, and the lack of rights-based sex education in schools have also continued to persist. We'll now move on to the second part of this presentation, which is rights denied and standards not adhered. So these four young orang asli women were essentially denied the right to education in a safe and secure environment. In fact, repeated incidences of bullying and discrimination faced by these young women eventually led to the loss of interest in schooling and them eventually discontinuing their education. In both Siti Fida and Chipang's accounts, bullying towards them was not actively discouraged by some of their teachers, and their requests for support were often ignored and responded to with inaction. However, it should also be noted that some of these young women also had teachers who were supportive of them and impacted their experiences in school positively, as recounted by Rosita and Yaliana. Here, it needs to be emphasized that teachers do have the capacity to make schools safer and more inclusive for orang asli students when they understand the struggle that these students are facing. Additionally, these young orang asli women were also not protected from discrimination on the basis of their identities as orang asli, when it was very clear that the bullying and discrimination they faced stemmed from the stigma and prejudice surrounding orang asli culture and heritage. In Yaliana's case specifically, a figure of authority or an ustazah even perpetuated stigma and prejudice in the presence of her peers. Fortunately, Yaliana was able to escalate this matter to a different teacher, and this ustazah soon changed her attitude towards orang asli students after going through counseling. There is also a clear failure to ensure accessible education for these orang asli girls by the authorities, as most of them recount living away from their parents in dorms to be able to attend school regularly. Limited access to education will eventually have an adverse impact on the student's decision to remain in school, which in turn may be a possible contributory factor for the privation of economic opportunities and generational upward mobility in these communities. The lack of safeguards and measures to address and prevent sexual abuse and harassment in schools, as recounted by survivors via the Save the Schools Malaysia Instagram, is also a denial of education. These survivors were clearly denied a safe, appropriate, and conducive environment as students, which then impacts their overall mental and physical safety and well-being. Harmful acts such as period spot checks were also not actively prohibited by schools, as teachers actively carry out these acts in the to disguise the fact that they were trying to impose discipline and obedience. In conclusion, the testimonies from 4 orang asli girls and Save the School Malaysia's survivors both pinpoint the consistent failure of school authorities in ensuring their students' safety. They fail to investigate students' allegations and protect their students by addressing backlash faced by these students. They also fail to discipline perpetrators or report these perpetrators to enforcement agencies. We will now move on into recommendations.